Today we'll learn about students' free speech on social media, focusing on two cases about students' posts on Snapchat. In the first case, Mahanoy Area School District VBL, a student, after failing to secure a spot on the varsity cheerleading team and also feeling frustrated about her position in the private softball team, took to Snapchat to vent. She posted a photo of herself and a friend with their middle fingers raised, accompany a caption full of frustrations and explicit language directed at both the school and the cheerleading team. The student's post was made off campus on a weekend, and it quickly spread among her peers. Although intended for her private circle of about 250 Snapchat friends, the post was screenshotted and shared more broadly, eventually reaching the school's cheerleading coaches. The coaches, upon seeing the post, decided that the students' actions violated the team and the school rules, which demand respect and prevent foul language and inappropriate gestures. As a result, they suspended her from the junior varsity cheerleading team for the entire upcoming year. The case escalated to the Supreme Court, raising critical questions about the extent of a school's authority over off-campus speech. In this case, the location and the time of the speech were the key factors. If the student's social media message was posted on campus during school hours, the school may have had more legitimate reasons to discipline her, because schools generally have broader authority to regulate speech and conduct that occurs on school premises. However, because her speech was made off campus and outside school hours by using her personal cell phone, the Supreme Court, in an 8-1 decision, found that the school's disciplinary action violated her First Amendment rights, emphasizing the limited authority schools have over off-campus speech. The court noted that, geographically speaking, off-campus speech generally falls within the responsibilities of parents rather than schools. This acknowledgement implies that when it comes to the regulation of speech outside the school environment, courts should exercise greater skepticism towards a school's authority to regulate off-campus speech. This is particularly important in cases of political and religious speech that are made outside the school or school-related activities, where the school bears significant burden to justify any intervention. In those scenarios, parents have the primary responsibility for guiding their children's upbringing and expression. Allowing schools to regulate off-campus speech would grant them significant power over a vast amount of students' speech and expression. The court expressed concern that this could lead to overreach and excessive interference in students' lives outside school. From the student speaker's perspective, regulations of off-campus speech, when coupled with regulations of on-campus speech, include all the speech a student utters during the full 24-hour day. That means courts must be more skeptical of a school's efforts to regulate off-campus speech. For doing so may mean that the student cannot engage in that kind of speech at all. Suppressing students' off-campus speech would have a chilling effect on their willingness to express themselves, especially on social media and in other public forums. This is particularly concerning for speech that does not disrupt the school environment, such as political or religious expression conducted outside school activities. The Supreme Court also noted that the school itself has an interest in protecting a student's unpopular expression, especially when the expression takes place off campus, because America's public schools are the nurseries of democracy. In a democratic society, it is essential to maintain a marketplace of ideas where different viewpoints can be expressed and debated. Suppressing student speech, particularly unpopular views, would be detrimental to this democratic principle. What would happen if the student used a school computer to post social media messages in this case? The use of school property, such as a school computer, even after school hours, blurs the line between on-campus and off-campus activities. This could potentially give the school more leeway to argue that the speech falls under its jurisdiction. Moreover, the use of a school computer may be subjected to specific school policies regarding acceptable use. Schools generally have more authority to regulate how their resources, like computers, are used by students. If the speech violates those policies, the school may have a stronger base for discipline. Here's another case, very similar to the Mahanoy area school district case. In this case, a student was off campus at a thrift store with 3 friends. He took a picture of his friends wearing wigs and hats, including one hat that resembled a foreign military hat from the World War II period. The student posted the picture on Snapchat and captioned it with offensive language. The post, including the photo and the caption, was visible only to Snapchat users connected to the student. The post was deleted a few hours after the posting, and the student that posted on his Snapchat story, "I'm sorry for that picture, it was meant to be a joke." One of the student's Snapchat friends took a photograph of the post before the student deleted. She showed the photo to her father. The father called the police, who visited the student's house and found no threat. The picture and the caption were posted on Snapchat on Friday. Then on Monday, Dean of Students told the students that he was suspended for 5 days while the school investigated. 2 days later, the school extended the student's suspension 5 days to facilitate an expulsion review, and then another 11 days to allow for completion of that review. Next, an expulsion hearing was held, and the hearing officer recommended expulsion. Then the superintendent informed the student that he was expelled for 1 year for violating district policies. The student appealed, and the school board affirmed the superintendent's expulsion decision. The student and his parents filed a lawsuit claiming that the school district violated his constitutional right under the First Amendment. What do you think? Do you think the school district violated the students' constitutional rights? The school district argued that it had a reasonable expectation of substantial disruption, which it claimed did in fact occur, and interference with other students' rights to access education. The school district's evidence include the school principal received emails about the post that had been widely circulated throughout the area's Jewish community, and the post had scarred, angered, and saddened a family who said their son was worried about having a class with the student who sent the post. But the 10th Circuit noted that the evidence did not support a reasonable expectation of substantial disruption that would warrant dismissal of the student. First, there was limited evidence of disruption. The 4 emails from parents, while indicating some level of concern, did not conclusively demonstrate that the post led to a significant or widespread disruption in the school environment. Second, principal's perception versus actual disruption. The school principal stated that he has a feeling that the learning environment had been impacted. The principal's feeling was noted by the court. However, the court emphasized that merely impacting the learning environment does not equate to substantial disruption. The disruption must be significant and not just a subjective perception of impact. Third, the use of advisory period. The fact that the student's post was discussed during an advisory period was also considered. Advisory periods are scheduled times specifically meant for addressing different matters, including potential issues arising from student behavior or speech. In this case, an advisory period is a scheduled block twice a week implemented specifically for dealing with such matters. The court reasoned that using this designated time for discussion does not constitute evidence of substantial disruption. The advisory period's very existence and purpose are to handle such issues without disrupting the regular educational process. In essence, the 10th Circuit's decision suggests that while the school district may have had concerns about the post impact, the evidence provided did not rise to the level of a substantial disruption as required for disciplinary action under the Tinker standard. The standard for substantial disruption is high and requires clear and objective evidence that the speech significantly interfered with the school's operation or other students' rights, which the court found lacking in this case. This decision highlights the balance between the authority of schools to maintain order and the First Amendment rights of students, particularly regarding speech outside the school premises. When it comes to students' free speech, educational administrators need to pay attention to 4 key factors. First, location of speech, on campus versus off campus. The Supreme Court has historically given schools more leeway to regulate speech that occurs on school grounds or during school activities. However, regulations of off-campus speech is more contentious and limited, as seen in cases like Mahanoy Area School District. Schools' authority to regulate speech diminishes significantly when it occurs off the school grounds and outside school-sponsored activities. Second, time of speech. Speech during school hours or at school-sponsored events is more likely to be regulated, especially if it disrupts the educational process. But speech outside school hours, including online speech, is less likely to be under the school's jurisdiction unless it has a direct and substantial impact on school environment. Third, nature of the speech. Under the Tinker standard, students can regulate speech that causes a material disruption of school activities or invades the rights of others. Material disruption involves more than just a distraction or a minor disturbance. It must be something that substantially disrupts or interferes with the normal activities of the school. This can include severe disruptions to teaching, the inability to conduct school activities, threats to the safety of the school community, or significant administrative challenges. The Tinker standard also includes the potential for foreseeable disruption. This means that if a school can reasonably predict that a certain type of speech or expression is likely to cause substantial disruption, it may have grounds to regulate that speech preemptively. Schools must provide clear evidence of material disruption. Mere discomfort, disagreement, or offense caused by the speech is not enough. The disruption must be real and substantial. For example, if a student's speech leads to widespread protests, significant classroom disturbances, or threats of violence that require administrative intervention, it could be considered materially disruptive. Moreover, the student's obscene, vulgar, or lewd speech can be regulated by school. For example, a student gave a speech with sexual innuendos at a school assembly. The Supreme Court upheld the school's decision to discipline the student, stating that the school could prohibit lewd, indecent, or plain offensive speech. This court decision established that schools have a role in teaching students the boundaries of socially appropriate behavior. Also, the school can restrict students' speech that promotes illegal drug use at a school event. For example, a student display a banner with a message seen as promoting illegal drug use at a school event. The Supreme Court ruled that the school could lawfully restrict students' speech at a school event when that speech is viewed as promoting illegal drug use. This case clarified that schools could take actions to safeguard students from speech that is contrary to their educational mission. Here is my question for you. In light of evolving nature of communication, particularly with digital and social media platforms, how do you think the concept of material disruption should be interpreted and applied in the digital era? Are there any specific challenges or considerations that should be taken into account to effectively balance the rights of student speech with the need to maintain a safe and conducive learning environment? Please leave your comments below. Thanks for watching. I'll see you next time.